I think let's call this next panel to order. So as you know from the last, order please. From the last panel, I'm John Nuechterlein with TPI, and I have the good fortune of being joined by a couple of leaders in their respective fields. So first we have a familiar face to this conference. Jim Speta is the Elizabeth Froehling Horner Professor of Law at Northwestern, where he has taught since 1999. Jim was the interim dean of Northwestern Law School during the pandemic, which sounds like one of the most thankless jobs in academia. But he is an expert on telecommunications, internet policy, antitrust, administrative law, and many others, and also is a close watcher of the Supreme Court. Ian Gershengorn is a partner at Jenner & Block. He was the acting Solicitor General at the end of the Obama administration, so he was the government's chief litigator before the Supreme Court. And his involvement in the Supreme Court goes way back to his clerkship for Justice Stevens in OT 94. Do I have that right? Yes. And so today we're going to be talking about developments in the Supreme Court with some focus, but not exclusive focus, on topics of particular interest to this conference. So this is my third summer doing this panel. 2 summers ago, we talked about Loper-Bright, which had just been decided, and the demise of the Chevron deference doctrine, and more generally developments in administrative law. Last year, we talked about the Supreme Court's response to the early days of the Trump administration. We talked about the shadow docket, but a big question for us was the extent to which the court would serve as an effective check on the new imperial presidency. And the jury was still sort of out by then. It's to some extent come back in because another year has passed, and you have a divergence of views on that topic, which we're going to talk about today. On the one hand, you have people like Ely Mistel, who claims that the Supreme Court is a mere rubber stamp for the Trump administration. Justice Kagan rather famously went on the defensive to claim that no, the Supreme Court is not really a rubber stamp for the Trump administration. On the other hand, you have the president himself, who, I'm just going to quote from one of his social media blasts I think it was after the tariff case was decided. He described the justices in the majority, and there were 6 of them, as fools and lapdogs for the rhinos and the radical left Democrats. So one of these sides must be wrong, and perhaps both of them are wrong. And so we're going to dive into that. And I'm going to start with Ian. Ian, how do you see the Supreme Court managing its institutional role in this rather unprecedented era of political polarization?
Yeah, so thanks, John, and it's good to see everybody. I think as we think about these questions, I think it's worth thinking about the 2 underlying themes that are animating the debate as we talk about these kinds of issues, about the court and political polarization and rubber stamp, et cetera. The first is there's an open discussion of the justices as sort of political actors and the impact of that on the court's legitimacy. And if you think about it in one way, you can start with the Chief Justice's confirmation, where he talked about justices as umpires calling balls and strikes. And another view, perhaps by sort of more liberal critiques, suggesting that the court is nothing more than like a JV Senate. And so the first question that comes before us is nobody who seriously looks at the court thinks they're either umpires or senators. And the interesting question that these decisions from this last term and these debates are having are where on the spectrum between umpires and senators is the court and where should it be? And then the second one is the idea that John started us out with, which is sort of the court's role in the constitutional system, and in particular, its interaction with the administration. And if you think about it, it's a tricky thing for the court, right? It has no army, right? It depends on the executive branch and all of us to get its opinions enforced. There's a very aggressive executive. John's quote, made that clear. A sitting president showed up at oral argument for the first time in history during the birthright citizenship. And so there's a direct challenge to the court. And then the third branch, Congress, isn't really pushing back on the presidency. And so the court's role, in deciding, is it going to be a rubber stamp? Is it going to push back? Is really teed up for the court. So that leaves the question. I think this last term has left us, without a solid answer. I think on the one hand, you have cases like tariffs, birthright citizenship, the National Guard case from Illinois, the attempted firing of Lisa Cook from the Fed, that suggests that Justice Kagan really has something, to say, where she says that it's a bad rap for the court, that it's not really a rubber stamp. On the other hand, the White House had, or the executive branch had, 22 straight wins on the emergency docket. Some of those are hugely important: firing federal employees, vast expansion of executive control over agencies, grant cancellations in billions of dollars, immigration enforcement. And, the court has been very much a part of helping the executive branch advance that agenda. And then the last thing I'll say on that is I think what the court has also done, when you think about, is it a rubber stamp? What the court has done, I think, is shift the Overton window a lot for the executive branch. And things that would have been unthinkable even as recently as 5 years ago have now become arguments that are getting 3 or 4, sometimes 5 votes in the Supreme Court. And so is it a rubber stamp? I would say no. But has it enabled the executive branch? Yes. And will the ultimate answer to that question be known? Is it knowable today? No. I think we need a few more terms.
I have a slightly different take on that, but I agree with the bottom line. Neither senators nor umpires, allegations to both extent are overstated. But as I look at the cases that the president lost this year, none of those cases, save one, which doesn't get mentioned as much as it should, is a loss to my mind of the structural governmental power of the presidency as an institution. And I'm saying that because I don't think that Cook is yet a win. Cook is a case the administration lost, but there's so much uncertainty about what's going to happen at the next step as to both the Fed's independence and as to whether there are other institutions in the government that might fall on the Cook side instead of on the Slaughter side. My read of it is that almost everything's going to fall on the Slaughter side, but some of the really wild card questions like the civil service and the private corporations, et cetera, I'm just not sure there's much of a win in Cook for those who opposed the overruling of Humphrey's executor. I'll just make this point on the Overton window. The Department of Justice never before, under powerful presidents of all political stripes, asked the court to overrule Humphrey's executor. And this administration did, because this court laid the groundwork for that argument falling inside the Overton window. Tariffs is a loss for the government, but it's not a structural issue. Birthright citizenship is a loss for the government so far, but it is not a structural issue about the president's power. The only one that's sort of a structural issue in our politics is the loss of the Trump administration in Watson versus RNC, which is the mail-in ballot case. That's my read on the Supreme Court.
So you've mentioned Humphrey's executor and Slaughter and Cook. Let's do a little deep dive into that, because I know it's of particular interest to a number of people in this audience because of its sort of immediate consequences for a couple agencies that we care a lot about, which are the FCC and the FTC. Ian, walk us through what the court held and what you see as the lessons, to the extent to which you see those decisions as emblematic of the court's view of the administrative state.
Yeah, so I mean, just to level set, this debate about the role of Congress in hindering the president's ability to fire the people in the administration dates back to the founding, where there were discussions about whether Congress should have a role, whether in fact Congress needed to sign off on the firings the way it has to sign off on with advice and consent. And as you all know, sort of in the late 1800s, early 1900s, Congress started creating agencies and put in for-cause protection. And then in Humphrey's executor, famously for the FTC, the court unanimously, looking back, 9-0, held that Congress could put such restrictions on. As Jim said, the court began to lay the groundwork for overturning that with, I think, two main sort of themes. Obviously, a lot goes into it, but two main themes. One is, as a matter of text in the Constitution, the executive power is with the president, and that became more and more a part of the court majority's views. And second, sort of a need for accountability, that you had these agencies that were headed by people who were not elected, doing really consequential things, as everybody in this room knows. And who do you blame, right? It's not Congress, they didn't do it. It's not the president, he can't fire them. And so, you have this headless fourth branch, and it creates real problems. So, as Jim said, this issue has been percolating and bubbling for a long time, but no president had actually sort of teed it up until President Trump, who came into office and fired commissioners from the NLRB, the MSPB, and then ultimately Rebecca Slaughter, the commissioner from the FTC, which was the very agency at issue in Humphrey's executor. And the court ultimately held, 6-3, that for-cause removal protections of the kind that had been approved in Humphrey's executor and that extend to agencies like the FTC, the Fed, the NLRB, the MSPB, FERC, et cetera, were unconstitutional. I think importantly, maybe Jim would disagree, I think there was a companion case, this Cook case, where the court said that doesn't extend to the Fed, which leads to a natural question of why? And the court said that there was a historical tradition dating back to the first and second national banks of treating monetary policy differently. And basically, there was a settled constitutional tradition that monetary policy should not be subject to political interference. And therefore, 5 justices on the court upheld for-cause removal protections for the Fed. So what does this mean? Well, first, it's a big deal for the executive branch, and I think a real shift in power to the executive branch. Congress over the years has given a lot of power to these agencies, including not just enforcement power, but sort of the ability to try judicial power, and certainly the ability to regulate, a legislative power. And part of the deal was that those were independent of the executive branch, and as a result of Humphreys, the powers all stay, but the check is gone. And so there's a real question about, would Congress have done that? Is it a bait and switch? That's a fair question. The justices talk a little bit about it, but the bottom line is the executive branch, I think, gets a lot more power. The second big thing is that I think there are a lot of administrative law challenges coming, and Justice Gorsuch sort of spells those out. He says, yeah, look, this is a big change. It's a big concentration of power in the executive branch, but that's not a good thing. But there are other doctrines that take care of it. There should be non-delegation doctrine challenges, increased reliance on the Seventh Amendment, due process, void for vagueness. And so he sort of set out a laundry list of administrative law challenges that he is invited to deal with this issue that the court has somewhat created, where it creates reliance for Congress in Humphrey's executor, and then takes it back now in Trump v. Slaughter.
Let me be clear. I think Cook is a very important win for the administrative state. What I don't think is necessarily that the for-cause protection is going to end up being interpreted in any vigorous manner. And the president has already made clear he's going to press the case. And I think he will press the case. And the second is, I don't think Cook really opens up an argument, for example, the argument that, it's settled that the agency that deals with such fundamentally First Amendment issues, FCC infrastructure issues, ought to be independent in the way that monetary policy ought to be independent. And Blair Levin wrote a nice piece on the TPI blog not too long ago that explains, I think quite rightly, why that sort of argument is probably not a winner in the FCC's case, and I generally think it's not a winner as to the principal officers of any of the other agencies other than the Fed. I'd like to be wrong as a New Dealer, but, you know.
So I'm going to ask one more question about Humphrey's executor, but then I want to move to other topics, in part because there's a whole panel tomorrow on Humphrey's executor and what it means for the FTC. So I'm going to shift to what Humphrey's executor means for the FCC, because it actually means something a little different for the FCC than it does for the FTC because of a statutory difference in the organic statute for the two agencies. Ian, do you want to walk us through that?
Yeah, sure. So among other things, as the chairman said in his testimony to Congress in last December, the FCC actually does not have for-cause protection in the statute. And so there has been sort of this sense that the FCC is independent, but it's not actually in the statute in the way it is for the FTC and many of the other statutes that we've talked about. Interestingly, the SEC is in the same situation, although the court has sort of assumed independence, the equivalence of for-cause protection there. I think what's likely to happen in the FCC is a shift then to a focus on the quorum requirement and the political balance requirement, and whether, for example, it would be either doable and or lawful to fire the lone remaining Democratic commissioner, maybe have a 3-0 commission. And so questions about quorum and the political balance requirement in the FCC may well come up. Now, there's a counter story there that it might not be worth it. What's the point of getting rid of a dissent? You have a 2-to-1 majority, and all you're doing is casting legal doubt on a whole series of policy initiatives. So whether this comes out in practice or whether it remains kind of the debate for sort of court watchers and legal academics remains to be seen. But those are the kinds of things that will at least be percolating at the commission.
Yeah, and I think that statutory difference is a reason why Ana Gomez still has a job, and Rebecca Slaughter and Alvaro Bedoya do not. And the reason is that the statute for the FCC seems to suggest that the agency can't lawfully act if the number of commissioners in one political party exceeds the quorum of the full commission. So Ana Gomez's continued presence at the commission may be a reason why she hasn't, it may be the result of that statutory quirk. There would be very significant legal challenges to any FCC action taken by a commission that consists solely of Republicans.
Can I have 45 seconds on that?
Yes.
So two of my good friends, one of whom's in the room, Christopher Yu, and the other is a colleague, Stephen Calabresi, I think would tentatively say that partisan balance requirements are not in the same category and might be upheld, or it will be upheld. Steve has already said they would be upheld. And I'm doubtful, because I think the theory of Slaughter and the other cases that preceded Slaughter will set the stage for what would be to the majority of this court, a very acceptable argument that a partisan requirement too much interferes with the president's appointment authority, which is much clearer in Article 2 than the president's removal authority, which we all know exists nowhere in the text of the Constitution. So.
Yeah, although even if the Supreme Court were ultimately to agree with that position, which I think is an open question, it would take several years for that to be found out. In the meantime, telecommunications policy would be in this state of limbo as we all try to figure out whether the FCC's orders are valid. Let's move to a couple of issues of particular interest to the tech and telecom communities. And Jim, I'm going to ask you to take the lead on these two. The first one is a case that I was briefly involved in, which was back when I was in private practice, and that was the AT&T versus FCC, the challenge to the FCC's forfeiture authority.
Right, and this case was framed as a follow-on to SEC versus Jarchese, which has been talked about here in previous years, in which the court had held that the Seventh Amendment required a jury trial if the SEC sought a civil penalty for securities fraud. And the same argument, constitutional argument, was made in FCC versus AT&T when the FCC put in a forfeiture following informal proceedings. Now, the Supreme Court held that there wasn't the Seventh Amendment issue because the statutory scheme that the FCC was operating under meant that the forfeiture order was not conclusive, that there was no obligation to pay the forfeiture order unless and until the FCC went to court and got an enforcement order. And the court said, overruling but not acknowledging that it was doing so, a long interpretive history, that the statutory provision that the FCC's order was prima facie evidence didn't mean anything in terms of deference from the court, and that in an enforcement proceeding, the FCC would bear the burden of proof and the trial would be de novo. And so because the statute rendered the penalty inconclusive, that meant there was no Seventh Amendment issue. Now, for those of you who live in the weeds, like I used to of FCC law, there's still a little bit of an openness because there are formal procedures that can lead to forfeitures. I think they'll end up in the same bucket. And in fact, I think where we're going largely in the lower courts and in the Supreme Court following Jarkissi is that there's going to be a very small remit for monetary penalties coming out of administrative agencies. Not none, but as I said in a different conference, if some agency tells your client to pay money, really go ask your lawyers if that's true anymore. There will be some, and the Seventh Circuit, for example, an opinion by Judge Scudder 2 days ago, said that the banking authorities could issue those sorts of penalties without going to court. But that is definitely the trend that we're seeing, and FCC versus AT&T, although a statutory case, is a step in the same direction. And because the language of the FCC Act comes from the ICA, the Interstate Commerce Act, and so many other agencies' language comes from that act as well, it's going to proliferate beyond the FCC.
So the second case I want to ask you about, Jim, is Cox v. Sony, which flew a little bit under the radar. Obviously not for people who follow copyright law developments, but it was a case involving the potential contributory infringement by ISPs for various copyright infringements by third parties. It's fair to say, I think, that the ISPs dodged a bullet in that case, that the world might be quite different if it had come out the other way.
They did, and it's an important case. It's an important follow-on to Betamax and Grokster. The Supreme Court, the case there involved whether ISPs that did not terminate service to subscribers over whose IP address there were repeated copyright infringements would be contributorily liable under the Copyright Act. And the Supreme Court said no, and as it recast the contributory liability doctrine, it said that the contributory liability doctrine required evidence of intent, specific evidence of intent, which could only come in one of two ways. Proof that there was inducement, as there was in Grokster, advertising, we have a technology to help you infringe and that's why you should buy it, or intentionally providing a service which is tailored to infringement. And framing it in that sense wipes out a whole bunch of lower court cases from many circuits that had moved in the direction of saying contributory liability could be shown by knowledge and material contribution of the technology to the infringement. So it only asks at that second stage whether there's a legal use for the product, and if there's any legal use for the product, then there's no intent sufficient for contributory infringement. Now, that's a big deal. I think it's a bit unstable for two reasons. The first reason is it's unstable because the opinion, notwithstanding the broad statement of the rule, includes a lot of discussion of the things that Cox did, the ISP, did do with respect to copyright infringement. They had a policy in their terms of use against it. They sent out a lot of warnings. They did terminate occasionally for copyright infringement. And those sorts of facts are relevant to the question of product design, as Grokster would have put it. So maybe that discussion will cause some instability in applying the broadest possible reading of this new, narrower contributory liability. The second thing that makes it unstable in my view is that I think Justice Sotomayor's concurring opinion, in which Justice Jackson joined, is probably right that that's not how contributory liability generally works in the law. And so I teach torts, among other things, and it's clear that in tort law, if I sell you a hammer and you go out and do something bad, like hit somebody in the hammer with it, I'm not liable. But if you come into my hardware store and ask me to sell you a hammer that is particularly good for smashing someone's skull, you know, it's heavy enough, it's got the right angle, it's got a good handle, et cetera, and I sell you that hammer, I'm liable, okay? And that's the doctrine of contributory infringement. Now, what I think more broadly is going on here, and Pam Samuelson has written about this, is the court would very much like to narrow the doctrines of contributory infringement across the IP landscape and prod Congress to do something to put more definition around what those doctrines are. The court sort of generally has this idea that it's going to prod Congress to do things, and that hasn't played out so well in terms of Congress doing things. But I think it's a really important case. It's not as important as the broadest language in Justice Thomas's opinion for the court might suggest.
Hey, John, can I just jump in for 1 second?
Yeah.
I mean, I just want to pick up on that last point that Jim made. A lot of the doctrines that we would talk about in administrative law and in others are situations in which the court is functioning or assuming a landscape in which Congress could step in, or at least the doctrines would be very different. If you think about some of these ad law doctrines like major questions, where Congress says, where the court says the administration can't do such and such, that's really for Congress. If we had a Congress that said, thank you, court, for giving us this very difficult policy question, I can't wait to make the very difficult judgments and pass a statute, like nobody would care about the major questions doctrine, right? Because Congress would do what it's going to do. But what's happening, and one of the reasons the court has become the focus of so much attention, is that Congress isn't doing that, right? And so the court's word is the last word. And so when it makes a ruling like it does in Cox, or major questions affecting climate change, and student debt and things like that, and says, well, Congress will fix it, but nobody thinks really in the real world that Congress is fixing it. It means the power is being concentrated at the court, and the court is getting the last word on these things rather than Congress. And so this gap between this theory of how the Constitution should work, which is the difficult policy questions get made by Congress, and the real world where Congress isn't doing that, is creating a lot of pressure on the court and a lot of pressure on agencies, and is sort of fomenting this debate about what the court is, what it should be doing, and how it should be handling these things.
So
Yeah, 100%, yeah.
I think no discussion of this past term would be complete without a conversation about the two perhaps most headline-grabbing cases, apart from tariffs, which we kind of briefly touched on before. The two cases I have in mind are the voting rights case and the birthright citizenship case. I'm going to ask Ian and Jim, respectively, to address those two cases.
Sure. Well, I'll take the voting rights and I'll start. So that's Calais, the case of Louisiana versus Calais, and that involved a challenge under the Voting Rights Act, Section 2 of the Voting Rights Act, to a Louisiana redistricting plan that had created two majority-minority districts. And it teed up for the court questions about how to think about challenges to allegedly race-based redistricting. And the bottom line is the court significantly altered the way that such claims are going to be understood at the court. And at core, what the court said was that if you as a legislature do something for partisan reasons, to help Republicans or help Democrats, that is a defense, and it is a defense to a charge of racially based gerrymandering. And importantly and similarly, it said to plaintiffs, if you want to come in and challenge a redistricting plan as racially motivated or taking too much account of race or disadvantaging certain racial minorities, you have to come up with a plan that does at least as good as the state plan did in terms of these political goals of helping incumbents or helping certain political parties. So what is the impact of all this? I'd like to four quick things. First, in places, particularly in the South, where race and party are closely correlated, The Voting Rights Act as a tool for challenging redistricting is effectually gutted. It would take almost a malpractice by the legislature to say, if they couldn't think to say, I'm just trying to help Republicans here, which is effectively a defense to the Voting Rights Act. Second, it is, and you could think this is good or you could think it's bad, but I think it's indisputable that this is the third in a trilogy of cases that has vastly weakened, and some would say eviscerated, the Voting Rights Act, one of the most important statutes in our history. Shelby County eliminated Section 5, which required the Justice Department to sign off on changes to voting rules, particularly in the South. Brnovich, a case from a few terms ago, changed the rules for Section 2 claims other than redistricting, and now Calais has changed it for redistricting. And so the Voting Rights Act, as an effective tool, particularly for minority voters, has been significantly weakened. Third, there really is a fundamental shift in how the court has been viewing partisan gerrymandering. In a case called Rucho a few terms ago, the court described partisan gerrymandering as incompatible with democratic principles and basically said it was unconstitutional, but we as a court can't do anything about it. In Calais, the court had shifted and said that that partisan gerrymandering, or sort of taking into account party, is a constitutionally permissible criterion that states may rely on as desired. And so that shift over the course of a very short time from this is sort of unconstitutional, we're stuck with it, to this is a traditional redistricting criterion on the same level as keeping counties together and not running across rivers and things like that, is really stark. And then the last, two more things, but the last main point is this is a big deal in terms of redistricting. There are estimates that this will affect as many as 19 House seats, not so much in 2026, where there was not much time, but 2028 and 2030. This is a big deal for politics. And then the last thing I'll say is when you think about going back to sort of where we started and the court as a political institution, it's cases like this that really make it very, very hard to separate politics from the law, right? Whatever the court did in this case, it was going to affect whether Democrats or Republicans were going to get more House seats. And so this effort to sort of disentangle the court from politics is sort of doomed from the start in some ways with cases like this that just show you that they're inevitably entangled.
And I just add that the point about prodding Congress and Congress's inability to act, I think is furthered by cases like this that increase the underlying partisan nature of the political system, right? And so some of this does trace back, to my mind, to decisions the court is making and not just Congress's own dysfunction. And you have to add to the cases like Shelby County that Ian talked about, the line of cases that this court has developed essentially disabling Congress's power under Section 5 of the 14th Amendment. Although put forward as an interpretation of the Voting Rights Act, it would be very hard, the Calais decision, it would be very hard to imagine that even if Congress rewrote the Voting Rights Act to try to do what it tried to do in 1982 when it amended the Voting Rights Act, that this court would uphold that as a constitutional matter. That's just my fear. Okay, birthright citizenship. I think I can be relatively brief here. It was so much in the papers. 6-3, the court rejected President Trump's very broad executive order attempting to rewrite the idea of when citizenship arises in the United States, away from the idea that anyone born in the United States becomes a citizen of the United States, with the limited exception of invading armies and
The council.
Right, yes, exactly. So although it was 6-3 for that decision, a concurring opinion by Justice Kavanaugh said he was deciding only on the statutory ground because the Immigration and Naturalization Act, as passed by Congress in 1952, embedded this idea, but he would not agree that it was a constitutional interpretation of the 14th Amendment. So there was 5-4, 5 justices who said that birthright citizenship was guaranteed by the text of the 14th Amendment, except in these limited circumstances. It was anticipated that the Trump administration would lose this. I think the consensus was more it would be 6-3 on constitutional grounds, or even possibly 7-2 on constitutional grounds. I think the decision is a little bit unstable, as many 5-4 decisions are, and we're already seeing a press in Congress to introduce legislation to rewrite this. There's a new executive order, which is narrow on its face because it decides only to target birth tourism, which was a target of a lot of the first case. Birth tourism on its own is a minor issue. According to the CDC, it's 10,000 babies a year. According to some people who really hate it, it's 70,000 babies a year. It's not a lot of babies. But it creates the opportunity for an inroad into the broad rule that the 5-justice majority said of birthright citizenship, because if we can take sort of practical consequences of interpreting the 14th Amendment into account, as the dissenters wanted us to do on this issue, we get a wedge issue into the constitutional issue. As someone who teaches in higher education, the executive order is incredibly important to us because it's yet another tool by which the administration will deny student visas and visiting scholar visas, which was an issue raised on the quantum computing panel
I want to ask you
as well.
a question about Justice Kavanaugh's concurrence, because it was sort of odd in a way. He said, okay, we have to accept the statute as really the statute incorporated the previous understanding of what the Constitution required, but we can now, if Congress decides to pass a new statute with a more restrictive view of the citizenship clause, then the Constitution can evolve to accommodate developments in society since the citizenship clause was enacted. So, for example, birth tourism is more of a problem today than it was before. And then there was a footnote with long quotes by Bork and Scalia saying, yeah, well, the Constitution can be a living document in certain contexts. What did you make of that?
I think the law is broad and capacious, and the arguments that people will make under it. No, look, I think even the other dissents, the stronger dissents, the dissents in the case have flavors of things have changed since we last thought about birthright citizenship, whether it was in the prior Supreme Court cases or in the time it was passed in the 14th.
But do you think that his position is consistent with an originalist approach?
No. But I don't think I don't think that there's a consistent core to originalism as a constitutional methodology. I'll lay my cards on the table, but it's a particularly, you are right to call it out as a particularly open example of justices describing their methodologies. Now, the footnote to Bork and Scalia described himself as something like a tepid originalist, a faint-hearted originalist, right? And I think that was very true of him, notwithstanding that he was a principal advocate of the methodology at a broad level. So.
But John, part of this too is it is part of an ongoing discussion at the court as to exactly what level you are an originalist, and it's happening in the Second Circuit, in the Second Amendment cases too, where the court, on the one hand, is very focused on the actual facts at the time of the founding, but also is saying things like the Constitution isn't trapped in amber, and even justices like Justice Barrett are saying that. And so this debate about at what level of generality are you talking about originalism, and is it the sort of the principles that animated it, or is it the actual facts at the time, is one that I think even within the conservative justices, they're having a dispute. And as I say, like birthright citizenship is one, the Second Amendment is another, and it's sort of an ongoing back and forth, and between that and then I think what Justice Kagan would say is a true living constitution.
Is it fair to say there's a lot of play in the joints, and the play in the joints allows justices a great deal of discretion as to how they vote in particular cases?
This exact same sort of level of generality issue is playing out statutory interpretation cases in front of the court. Justice Kagan says we're all textualists, but there are very different kinds of textualists. And there's a very, Justice Stevens, who used to be our main purposivist justice, is now being followed by some of the liberal dissenters. And let's talk about purpose, but you can also see it in some of the major question doctrines cases. You didn't talk about this aspect of the tariffs case, but the fight over what the major questions doctrine means in the tariffs case is a fight about how do we do statutory interpretation that is happening very similarly to the fight about how do we do originalism.
So I think we're nearly out of time, but we do have time for a couple audience questions. So Alan Rawl gets the first question.
Thank you. Fantastic discussion. Thank you. So what do you make of the way the court is treating presidential pretext, what some might call lying, and its implications for the presumption of regularity? And an example would be the Chief Justice is taken to quoting Judge Henry Friendly with regard to the statement that judges are not required to exhibit a naivete from which ordinary citizens are free. The Chief Justice quoted that in Commerce versus New York about why a citizenship question was going to be added to the census, and then most recently quoted it in the Lisa Cook decision when he was addressing whether or not she could be terminated for cause. Right after that discussion, he quotes, judges need not exhibit a naivete, et cetera, et cetera. So what do you think this is going to mean going forward for presidential declarations, presidential findings, and generally the presumption of regularity?
Go ahead.
I don't know, because in addition to the data points that you've offered, I would offer as a confounding data point similar to Justice Kavanaugh's concurrence is the TPS decision. And in the TPS decision, the court says, we're going to ignore all the stuff that's been said about Haitians, et cetera, and that doesn't play any role in our decision. So I don't know what the answer to that is. Some of the lower court judges have become explicit that the presumption of regularity is gone. The Supreme Court's never going to go that far under this Supreme Court or any other Supreme Court, at least I think so. But I don't know. What do you think, Ian?
I think the same. I mean, this is a real troubling issue for the court, and it's come up not just in that immigration case, but it came up in Trump versus Hawaii the first time. The court has been super hesitant to say that the president is discriminating. And so while it has said all the things that you said about, the court doesn't have to check its common sense at the door and show naivete, which the rest of us are, not subject, the court has been very, very reluctant, and I think will continue to be reluctant to say the president is discriminating. I mean, that the president is a co-equal branch. That's a big step. The court is doing its best, I think, to avoid saying that. There are cases coming up, through the system that involve allegations of retaliation, which may or may not reach the court and may or may not put the court to that test. But I think the court is very hesitant to accuse the president of discriminating, and I think that hesitancy will continue even as the court says, the things that you're quoting on pretext.
One more question.
Yeah, I do have to disagree with you.
Could you tell us who you are?
I'm sorry, Harold Feld.
Oh, I'm sorry, it's Harold Feld. Yes, okay.
Sorry.
There's a Klieg light right behind you.
I actually, first I just have to say, I have to disagree with you about the importance of Cox in that the real question that had been bedeviling the courts below was whether violation of the safe harbor itself was a source of liability, and the court said, well, no, it just means you don't get the safe harbor, and then it runs through its liability argument, which I think from an IP perspective is probably a more important part of the holding. But FCC we're seeing now, first of all, the question of, well, the wireless guys want their money back so they can not pay and do this all over again. But the interesting question of what do you do, especially given the two exceptions that were given in Jarkissi that the court doesn't decide in the FCC case, which is notably equitable relief, which the FCC has authority to do. It can issue injunctions. It can tell you, stop doing that thing that you're doing. And the other is the public, it's not the public interest, but
Public rights, yeah.
the public rights, where, you know, arguably things like spectrum and interference that have no, analog in common law would fall into the category. I'm curious if you guys have any opinions about FCC enforcement and what we might see going forward in either of these categories.
Yeah. So one of the reasons I mentioned this Seventh Circuit case from Judge Scudder, who's a conservative judge in many regards, is it adopts a very narrow reading of Jarkissi that focuses a lot on this question of, is it a public right? How similar was it to a common law action, et cetera? And I just don't think that's where Jarkissi is going or would go in follow-on constitutional cases in the Supreme Court. Now, Judge Scudder in the Seventh Circuit is absolutely right that because Jarkissi says they're not overruling Atlas roofing, you sort of have to go down that pathway, especially if you're writing a brief. But I can see arguments that, you know, spectrum interference is just about, it's nuisance law. It's the same as common law, nuisance law. Equitable relief is a harder one, and the reason I looked at John is I know he's thought a lot about equitable relief, particularly in the context of the Federal Trade Commission. But if I'm right that Jarkissi's broader reading is where the court is going on this, that means that anything that results in a monetary penalty, whether a traditionally conceived monetary penalty or not, is going to be subject to the Seventh Amendment. Pure cease and desist remedies, that may be something that the agency can still do. The question then is, how does it back it up once it has issued a cease and desist order?
How do you deal with seizure of equipment, which is one of the FCC's
How do I deal with it? If I'm right about where Jarkissi is going, the seizure of equipment is a private right? It's property. It's the seizure of property. But John, help me.
Well, I think we're out of time. I want to thank our panelists today for a really rewarding conversation about the Supreme Court. Thank you.
Thanks so much. That was great. So next up is lunch. Go up to the